Article 50 of the Treaty on the European Union is the mechanism by which any member state, acting in accordance with its own constitutional requirements, can trigger the exit mechanism in the 2-year period for negotiating that exit from the EU. Back in September of this year, Theresa May, the British Prime Minister, announced that she intended to invoke Article 50 on behalf of the United Kingdom by March 2017. That would then give a timeline for Brexit of early 2019. Now, the difficulty with adhering to that timetable for Mrs May is potentially the fact of a 3rd of November 2016 High Court decision of the English court. A number of parties had sought to judicially challenge the ability of the UK government to trigger Article 50 without having first sought the consent of the UK Parliament. 3 senior judges, exceptionally sitting together in the High Court, determined the issue and found that, for reasons going back to the 1688 Bill of Rights, the UK government, in exercising its royal prerogative powers, did not have the ability to influence domestic legislation and the fundamental rights of British citizens that would be involved in Article 50. Given that decision, there is a potential problem for the government with the March 2017 timetable. The extent of the problem is likely to be determined by what parliamentary consent requires. If it is a simple day motion, then that is likely achievable. But if primary legislation is required to be passed by both Houses of Parliament, then the timetable could be jeopardised. The first point to note on that is that the UK government has announced that it will be appealing the High Court decision. That will be heard by the UK's highest appellate court, the Supreme Court, between the 5th and the 8th of December 2016. For the first time in its history, all 11 Supreme Court justices will hear the appeal, which means that there can't be any question over whether a differently formed tribunal would reach a different decision on this fundamental constitutional question. It also means that each of the UK's 4 nation states are represented on the bench. Any decision may not come until January of next year, and whilst the government has expressed its confidence in the outcome of the appeal, perhaps the more significant issue in terms of timetable and the form of any Brexit will be if the court determines what form of parliamentary consent is required. A single day motion will be easily passed by the government, but if primary legislation is required, that does give room for manoeuvre to those MPs and Lords who may not have supported Brexit in the first place and now seek to impose conditions and delays to any timetable. Those conditions may involve conditions relating to access to the single market.